First, live, local. This is Fox 12 Now.
Hello everyone, Greg Nibbler here with Fox 12 Now. Thank you for joining us, and we are coming to you with this breaking news, it is that the Portland City Council is preparing to vote on the homeless camp ban that Mayor Wheeler has proposed. Now, this is a camping ban that would essentially make it illegal to set up a camp in the city of Portland, whether that's a tent or however that's defined, between the hours of 8 a.m. to 8 p.m. We're getting ready right now for this vote. As you can see, the City Council meeting has not started yet. It's reportedly going to be starting anytime now. We'll take you live to that when we get to it. But going back to recapping some of the things about this ban, if it is enacted today, if it's voted on and passed, it would be enacted on July 1st. So this wouldn't be immediately enforced. You'd have a couple of weeks, but not a long time before that would be going into effect. Again, 8 a.m. to 8 p.m. So that means during the night, it would be a little bit different. All right, we're seeing them pull up right now, so I'm going to bring up the sound on this as they get ready to, looks like they're announcing who's in the meeting right now. We do know that Mingus Maps is not going to be there. Reportedly, from the Oregonian, he's not planning to vote on this today, so that does leave 4 members to vote. So we'll see what the outcome is there. But here it is right now. We'll just go straight to it.
Agenda. Information on engaging with City Council can be found on the Council Clerk's webpage. The presiding officer preserves order and decorum during City Council meetings. The presiding officer determines the length of testimony. Individuals generally have 3 minutes to testify unless otherwise stated. A timer will indicate when your time is done. Disruptive conduct, such as shouting, refusing to conclude your testimony when your time is up, or interrupting others' testimony or council deliberations will not be allowed. If you cause a disruption, a warning will be given. Further disruption will result in ejection from the meeting. Anyone who fails to leave once ejected is subject to arrest for trespass. Additionally, council may take a short recess and reconvene virtually. Your testimony today should address the matter being considered. When testifying, state your name for the record. Your address is not necessary. Disclose if you are a lobbyist. If you are representing an organization, please identify it. For testifiers joining virtually, please unmute yourself once the council clerk calls your name. Thank you.
Thank you very much. First up is item 471. This is a first reading of a non-emergency ordinance.
Add utility operators code to govern utility access and use of the city right-of-way and adopt fee schedule for utilities operating in the city right-of-way.
Colleagues, this item is sponsored by Commissioner Rubio. But before I hand it over to the Commissioner, I want to say that this code helps the city achieve efficient outcomes for both the city as well as for our utility partners. This project has been underway for some time. It started when the former Office of Community Technology was in my portfolio under the leadership of Elizabeth Perez. Since then, the franchise utility program has moved to the Bureau of Planning and Sustainability, which is in Commissioner Rubio's portfolio. I want to thank Elizabeth and her team for their diligent work. Elizabeth has passed the baton to the Bureau of Planning and Sustainability, and their team is now doing the important work within the Community Safety Division. This code is an important step for our city to consolidate work and processes to create efficiencies and recover fair and just compensation for use of the public right-of-way from our partners who operate and use assets within that right-of-way. I'll now turn it over to Commissioner Rubio to introduce the ordinance.
Thank you, Mayor. Before I introduce the item, I want to make one amendment to the ordinance and 2 amendments to Exhibit A, which is the proposed city code language. And the ordinance amendment includes a new finding, which reads, number 9, the City Council adopted resolution number 37168 on November 12, 2015, which opposes the transportation and storage of fossil fuels in or through Portland or adjacent waterways. The resolution states that prior to any further council action related to code changes to advance the policies in the resolution, the mayor will schedule a work session to review proposed code changes and an executive session to review the legal considerations of any proposed code changes. Although it does not appear that this directive relates to the ordinance, the purpose of which is to codify existing utility franchise agreements. Out of an abundance of caution, because our utilities such as Northwest Natural, PGE, and Pacific Corp will be subject to this code, And these are the requirements that have been met as follows. First, the first reading of the ordinance fulfills the work session requirements, and the city attorney has met with each of the commissioners to discuss the legal considerations of the proposed code changes, so no executive session is necessary. As such, I motion to amend the ordinance to add Directive 9. May I have a second?
I'll second.
Thank you. The code amendments I am recommending are as follows. First, on page 5, bullet R, the proposal is to strike language starting on line 1 after the word "sell" through the remaining sentence and sub-bullets 1 and 2 and replace with section 12.15.030 definitions. R, small wireless facility or small cells means a small wireless facility as defined by the Federal Communications Commission in 47 CFR section 1.6002I and may be amended or superseded. I motion to amend Exhibit A to revise the definition of small wireless facility or small cell. May I have a second?
I'll second that one as well.
Thank you.
Can I ask just a point of clarification for the record?
Sure.
This second section, or this second amendment, is codifying our definition of small cell to be in alignment with the federal definition. Is that accurate?
No, I'm going to ask staff to answer that first. Andrew?
And please introduce yourselves for the record.
Good afternoon. My name is Andrew Spear, and I'm the Franchise Utility Program Manager for the Bureau. Could you
Of a small wireless facility as defined by federal code under the FCC, is that accurate?
Yes.
Thank you. That was my question. Glad you got the exercise, though.
Thank you. Okay, second amendment 0.090, utility-specific provisions. A, wireless services is amended to add a new paragraph 8 to page 18 and read as follows. Section 12.15.090A, notwithstanding section 140, will be paid annually for each year during the term of the license. I motion to amend Exhibit A to add a subsection to utility-specific provisions. May I have a second?
I will second.
Thank you, Mayor. The ordinance before us today adds a new chapter, includes regulatory provisions that treat all users of the row in a fair and transparent manner and responds to the full range of the different types of utilities, from pipelines to telecommunications. This effort has been a multi-year process that has included significant outreach with partners and changes to the draft code to address policy and operational concerns raised by the industries and companies governed under this code. Our outreach work has started internally, as some of our own bureaus are subject to this policy. And for several months, we worked with those bureaus directly, and with Commissioner Mapp's office in particular, as he had concerns related to the Water Bureau and the Bureau of Environmental Services specifically, and we incorporated that feedback. I want to stress some key points with you on the implementations of the code. The goal of this effort is good governance. It's not about increasing city revenues. A commitment that I made up front, that this code is not making changes to the fees or fee structures for what is in place currently. Companies that have current franchise agreements will continue to operate under their franchise agreements until the expiration date. Only after expiration will they be subject to the new row code. If a company wants to be subject to the new row code sooner, they can make that decision. This code mimics closely the same language and provisions that exist in current franchise agreements. And lastly, for licensees who pay on 5% of gross revenues currently, the calculation of gross revenues on Exhibit C of this ordinance simply clarify what is included and not included in the calculation for gross revenues, because there has been confusion in the past. Bureau staff have worked with parties to make edits to address policy issues raised and give additional clarity in both the code and administrative rules. And I want to share publicly that after this code is adopted, BPS will happily engage industry stakeholders along with all council offices to look at costs associated with the right-of-way. I will now pass off to Director Oliveira and Andrew Spear to present the ordinance in more detail.
Welcome.
All right. Thank you, Commissioner, Mayor, Commissioner Gonzalez, Commissioner Ryan. Good afternoon. Donnie Oliveira for the record, Director of the Bureau of Planning and Sustainability. As introduced, this ordinance...
We're troubleshooting. We may need a short recess to reset.
All right, why don't we take let's take a 5-minute recess and let the closed captioning, and then you can start over.
All right, that was a kind of jarring music there that they took, but as you heard, City Council is taking a brief recess to fix some closed captioning issues, but what you're watching right now is their meeting. What we're anticipating is going to be happening here during this meeting is the vote on the proposed camping ban by Mayor Wheeler. Now, again, this ban would be taking place on July 1st if it's passed today. July 1st is when it would go into effect. It would affect camps between 8 a.m. and 8 p.m. So those are the hours when you would not be allowed to have those camps. As far as the ordinance itself, several of them would be warnings. You get a number of warnings before you get a potential $100 fine, and then it steps up from there. So it's not an immediate necessarily an immediate removal from somebody who is set up in one of those camps. Now, they did have a large amount of public hearings about this last week, which you probably heard something about, and I would imagine that you did during this meeting last week, and then the results afterward to get us to where we are here today.
Have been left by those who attended today's City Council meeting as well as the rally beforehand. For nearly 5 hours, more than 170 people spoke in person and virtually for and against this proposed camping ban, with things at times getting contentious in the council chamber. A rally against Portland's proposed to have their voices heard on the ordinance. During public comment, the council heard from those in support of the proposed ban, saying businesses and residents in the city are being negatively impacted, and there needs to be more focus on affordable housing.
Unsheltered homelessness is cruel and dehumanizing. People are dying on the streets.
In a district struggling to recover, following workers and customers to feel safe returning, something needs to change.
They heard from those against it as well, who say it would not solve the homeless crisis in the city and would negatively impact those experiencing homelessness.
It discriminates against marginalized people who sleep during the day so they can stay awake at night when the risk of harm to them is the highest.
Asking homeless Portlanders, 60% of whom live with one or more disability, frontline workers, like a punch to the gut.
There was also several tense moments during the hours-long public comments.
You're gonna have to wrap it up. You're 2 minutes over.
You sold our city to bankers.
You're gonna have to wrap it up, please. Thank you. Thank you. Sorry. All right. All right, everybody, let's keep the temperature down, everybody.
This was just Fox 12 Oregon.
All right, so there we go. That was Chandler Watkins' report from last week. We are now a week from that moment. As you can tell, very intense. They had a really high number of people who wanted to make comments, public comments. During that, everybody got about 2 minutes apiece to speak, and they ended up not voting. We had thought they were going to be voting on it last week. They did not. Again, if you're tuning in here, the Portland City Council is taking a quick break to apparently fix some closed captioning issues, so we have it right there. Once it comes back up, we will. People have some pretty strong opinions on either side, as you just witnessed right there in that meeting from last week. The ban itself. So, if this goes into effect today, July 1st, that's when it would be enacted. It takes in that this would take place between 8 a.m. and 8 p.m. and I think that's one of the key components too that we've heard from both sides talking about is what does that mean as far as keeps people up at night, or vice versa as they're moving around. So those are some of the talking points that each side has. But you do get warnings. They said a third warning or violation would result in a citation that could result in a $100 ticket or up to 30 days in jail. Could. So how that's going to be enforced, again, that's a lot that's going to need to be determined here over the coming time if this is passed tonight. Other banned activities include leaving trash behind and lighting fires. So those would also be banned, but again, enforcement they are voting on with this. This is where we're at when it comes to this meeting. This does come on the heel of a lot of surveys that have been out recently. Groups, they are all very much for change as far as believing that the homeless situation, the houseless situation in the state is an issue, one of the top issues, if not the top issue, that they want legislators to tackle. So this is one of these proposals that is out. 5,228 homeless people in Multnomah County in 2022, and over 3,000 of those were completely without shelter. So this is all from various polls, from information that's been discovered on that. And the polls, again, largely saying that something needs to be done. This particular one, there are some very strong opinions on either side of that. As far as what, so we'll find out if the city council is going to be joining. One thing of note, too, there are 4 city council members and then the mayor who is there, so 5 total. However, Mingus Mapps is not there. He is not there in person. He's reportedly in Washington, D.C., and from a report from the Oregonian, does not intend to vote during this, and that means just abstaining, so not showing support one way or another. That leaves the 4 votes that are there. That could result in a tie. That's a possibility, and we'll see how the rest of them vote out. It looks like, from what we're seeing right now, they've got the closed captioning worked out, so we're going to go ahead and bring this back up right now. But again, we're watching the city council meeting live, voting on the potential camping ban.
Thank you, Commissioner, Mayor, Commissioners. Don Oliveira, Director for the Bureau of Planning and Sustainability. So as introduced, this consistent audit practices and code requirements that apply uniformly to all utilities. The right-of-way is the city's largest physical asset that we manage on behalf of all Portlanders. It is an essential public good. The proposed code before you adopts the current fees that compensate the city and Portlanders for the use of the right-of-way. The proposed ordinance does not change the existing fees we've been charging for the past several years. I want to acknowledge that we've heard concerns about potential FCC rules violations due to our fees for small wireless facilities, but our city attorneys have consistently affirmed that our cost-based structure is well within the city's authority to charge. In addition, what is not included in this code is the management and day-to-day operation, design, and engineering standards for the right-of-way. The code gives the city a uniform document that governs the legal requirements for utility use of the right-of-way. It is the priority of myself and my staff to ensure the code protects the right-of-way as an asset while ensuring the efficient administration of the code with our utility partners. As Commissioner Rubio stated, my team and I remain steadfast in our commitment to ongoing analysis and improvements with our partners on the components of the right-of-way that are outside of this code. I want to be really explicit, and no action on this code is status quo. Nothing changes regarding fees or revenues for the city. I will now pass it to our franchise utility manager, Andrew Spear, who will walk us through the code, specific provisions, and the incredible amount of stakeholder engagement and process we as a Bureau and our predecessor at the Community Technology Office have had to produce the ordinance before you. Edits to the code and administrative rules that address the key policy concerns raised by our utility industry partners. Thank you. Andrew.
Good afternoon. My name is Andrew Spear, and I'm the Franchise Utility Program Manager at the Bureau of Planning and Sustainability. Thank you, Commissioner Rubio. And administratively, this creates efficiencies across both the city and the affected utilities, consistent treatment of utilities who operate in the right-of-way, fair compensation for private use of a public asset. I want to point out that the last point around fair compensation is an important one when we think of the right-of-way and it as an asset held in trust by the city for Portlanders. As city officials, we need to ensure that we recover fair and just compensation so that we avoid subsidizing companies who are making profits due to their use of the right-of-way. Next, I will present a presentation to you and give some details behind our process and where we landed today with the code before you. This first slide provides a background of the value of the asset that the city maintains on behalf of Portlanders. You'll notice that the percentage of land mass within the city is roughly 20%. Most of that is made up of roadways and sidewalks. The value of that asset is estimated to be $13 billion, and essential services could only be provided except through use of the right-of-way. city manages the utility access of the right-of-way through franchise agreements currently. Franchise agreements are individual agreements between the city and an individual company or utility providing service where an asset needs to be installed in order to serve customers in Portland. Traditionally, we have had passive management with a large number of franchisees and license holders within the city. The revenue, I would like to point out, is that's the amount collected annually. A large portion of that revenue is calculated on a percentage of gross revenue, with other fee payers such as per-foot customers and the wireless providers on a per-site fee. I'd like to just provide some context on what the building permitting to access underground facilities. It's not the financial compensation for maintenance and operations of the right-of-way, and it is not a path to create advantages for a single utility within the city and utilities. Next, I just want to provide some context on the right-of-way code in general. That first sentence there is how I like to think about the right-of-way code or franchise agreements in relation to their operation with city right-of-way and install their assets. The purpose of this code is to reduce administrative burden, create a level playing field for utilities and customers alike, and ensure fair compensation of those uses. Next, this slide is just to provide some background on adopting like right-of-way codes to avoid franchise agreements. Franchise agreements traditionally are multi-year processes that require a lot of legal engagement and costs that have not been paid for by those instituting the incremental costs upon the city, i.e. the requesting company or utility of the franchise agreement has not paid or compensated the city for the legal services the city has provided in those negotiations. So I think it's an important point as we think about ensuring fair compensation during the process. In terms of stakeholder engagement, this has been a 2+ year process. As the mayor pointed out, started with Director Perez as part of the Office of Community Technology. There's been 2 formal rounds of public stakeholder comments held where staff reviewed comments, provided feedback, and adopted some changes. Since my coming on in March, we have had multiple rounds of stakeholder engagements with the core utilities, PGE, Pacific Power, and Northwest Natural. We have adopted changes given their feedback, namely in the areas of the definition of gross revenues. We've also had direct conversation and engagements with the wireless providers, AT&T, T-Mobile, Verizon, and then Crown Castle as a provider of services for the leasing of assets that the providers use and have leases for. We've made movement on key policy issues, given stakeholder feedback. And next I'll provide some comments. One of the delegates authority to the director, the bureau director, to then institute administrative rules for the definition, for further defining gross revenue calculation. We have before you an Exhibit C draft of that administrative code that includes the definition of what is included and excluded in gross revenues. We've made a large movement in policy with excluding the revenue associated with the recovery of franchise fees. The utilities on our bill line item excluded. It is the tax on a tax argument. So we remove that from the definition of gross revenues to add clarity, and wireless providers being subject to fees and not gross revenues. There was a concern by the wireless companies that the city was earned by us as Portlanders. We made clear in their section of the code that that is not the intent, that they pay on fees, per site fees, which are the natural was interested in a language change that provided the ability, if there was identified by the city and the utility for an asset to be safely. So we made clear language there that that is an option and that the city would be able to work with the utility on that matter. Current franchise holders, as was included within the code, that clearly it states that if you hold a current franchise in the city, that you will remain on that franchise. End of the Exhibit A. The purpose of this slide, I wanted to identify rationale is for given arguments or items that have been presented before you in terms of lobbying. Your utility license term is too short. There's also a provision within the city's charter of months, and so that's a practical matter. So within the code, a new license application, and we renew that. Also, when we think back to a good visual for you all to consider, when you think back to 2003, 20 years ago, when when cell phones were becoming more prevalent, and you think about the level of technology that existed then versus today, that generational change in cell phone technology, that would have been with traditionally franchise agreements had lasted 20, 25 years. And so the city would have been locked into the operating agreement between the company, the utility, and how their technology progressed for that 20-year period. This code allows us to adopt and implement new technology in a more responsive way that ensures recovery of incremental costs that utilities and providers impose upon the city in the right-of-way. Next, the cost study for small wireless attachment fees. I know that there's been direct comments and written and verbal comments given that the city is violating the FCC order by not having a just and reasonable cost that is based on facts. As Director Oliveira mentioned, we have gotten legal guidance and review that what we have calculated is within the code for the FCC order, which simply states that you are able to, cities, jurisdictions and cities are able to calculate just and reasonable costs provided that they are founded and within reason. And so the costs that I have calculated, the small cell fee, are just based on practical, administrative, and FTE costs, for most of the costs being within my team and the 4 FTE that are within. Next is number 4, competitive advantage over those with existing franchise agreements. The basis of this code was taken from both other jurisdictions and their right-of-way code and current franchise agreements that we have with parties, namely the most recent franchise agreement being in 2018 and implemented in 2019 with AT&T. When you mirror the two sides of the code and that franchise agreement, many of the key components remain, the language remains the same, and so there's no intent to have different prices or fees associated with the right-of-way code or the current existing franchise agreements across the different industries and providers that have franchise agreements. And the definition of gross revenues being included in code, that was a policy decision that the Bureau at the time made with regards to having a living document that could be able to be amended easily and be able to be responsive to both industry and city needs. The decision was to include a administrative rule that would be governed by the director, and the code delegates that authority to the director. Just practically, there's already two sections that I would like to include as revisions for when the code is passed and we go out to industry and we issue our draft proposal. I'd like there to be a clarity on fee payers, how they're assessed, and what timing in which they pay, and then also an administrative section that discusses the administrative process around the licensing and application fee. And then lastly, I wanted to note the items that Commissioner Rubio raised as the amendments. Those were two key items. The definition of small cell facilities, the city's definition of small cell facilities was included in a more defined and narrow manner than that of the FCC definition. And so in order to create some better understanding with our industry partners, we've made that change to adopt the FCC's order, which is a bit more encompassing of the different types of facilities that are included or not included within the small cell structure. And then lastly was the item on the fee payers for wireless companies and those being annual payments. Currently, they do pay us annually for their site fees, and so this just codifies that within their section of the code, which is wireless companies. I wanted to just provide you lastly with an overview of what you are considering. So Exhibit A is the chapter itself, the chapter of the row code. It is a new chapter within the city's code and is Chapter 12. Exhibit B is the fee schedule associated with the code. It includes the gross revenue payers, so the 5% of gross revenue, the wireless fees, i.e. the small cell wireless and the macro sites, and then the per foot fees along with the nominal administrative fees. And that concludes the presentation. I would like to thank the commissioner for her support, and I'd like to thank my leadership via Director Oliveira, and their support has helped us achieve and adopt changes to the code that I believe give meets industry where their needs are at, and helps the city understand its risk profile and maintain that through time to ensure that no undue risk is imposed upon the city given the code. And that concludes the presentation, and I will turn it back to Director Oliveira.
Thank you, Andrew. Commissioners, I just want to acknowledge, last night we sent an email over to your offices that were outlining these amendments that Commissioner Rubio shared this afternoon, and then once we had legal counsel's final review, we shared those this morning with you all. So I apologize if those didn't hit your inbox as soon as we would have liked, but that when those were conveyed. And again, we are fully committed to continuing the conversation, assuming this code is adopted, to working with industry to evaluate in a phase 2 format the fees and costs associated with the right-of-way, including our partners in the other bureaus.
Great. Could I ask a couple of questions? Please. And then I know we have some public testimony as well. So this is thick, and I want to make sure that I've got my hands around it. So to clarify what you had said in your presentation, what we're discussing today, this ordinance is specific to the program for managing access to the public right-of-way. So it is a narrowly defined ordinance. Is that correct?
Yes.
Okay. And my understanding, based on what you said, is, and we've seen a number of different charts, a number of different notes, a number of different spreadsheets. There was one spreadsheet that identifies the fiscal impact of this particular ordinance. This ordinance is referring to the $650-ish thousand that is going towards the specific management of the program as narrowly defined by this ordinance. Is that program?
There's my FTE of 4 to include myself time, and then a small amount of policy time that's related to a PBOT FTE.
Okay, and some of the testimony I received basically for small wireless is, and it showed our cost being about $1,400.
Be applying to the utility license and legal access portion, yes.
Yes. And I also saw some charts that, and then in addition to that, in addition to this $650,000 spread out over our 650,000 residents, there is a utility that does not change. This ordinance does not change that, the numbers behind that. Is that correct?
Correct.
Okay, and just out of that, just so I have some idea of that.
That is the kind of standard in which almost all cities operate within. Some are slightly above and have a privilege tax.
To manage the right-of-way entry program for 4+ FTE spread out across all of those poles at 1,400, the providers, but it was about $300,000 per provider for the 2 large providers per year for that fee. Is that about right?
Yes.
So, and one of those providers, I did a quick Google search, has revenues of $130 billion. Is that what we're talking about here?
Well, to clarify, it would be if gross revenues were assessed, it would be.
Right. I just did a quick Google search.
Sure.
And so I'm trying to just get some comparative idea of what we're talking about. But it looks like it's about 3.
Along with that, our costs stay flat. So as more small cells or wireless facilities, the costs go down per unit.
Okay, so you further said that there are no new fees or increases associated with this ordinance. Is that correct?
Yes.
There are other ways that cities would recover costs for this. One of the things I noticed as I did my very divergent means and diverse means of recovering these costs. For example, some city department, are we high, are we low, are we in the middle?
In terms of within the context of this program, at the standard, within the fees assessed to wireless, 270, Portland is on the higher end, but not the highest. Their industry has argued that we should do an equivalency study, and those costs themselves are reasonable, are non-discretionary, allowing localities to charge fees above the safe harbor. And so we have to use our own costs and structures, right? And this scope of work is unique and distinct. And so to use an equivalency study or an equivalency of another
ordinance in the city of Portland, you are saying that the legal requirement is that you may not charge more. You have been transparent about what the costs are associated with this program and the revenues collected to support it.
Yes.
Again, it was about $650,000 for 4 FT plus, I think some legal support or something else. So maybe the real concern is here, because I'll be honest, I'm not seeing it. Mentions but does not include any changes to the existing franchise fee agreements, which you say are center of target-ish, certainly not out of the ballpark. It is legally permissible under FCC rules, and it acknowledges there may be other city bureaus that charge. If you are going to construct something on the public right-of-way, you're going to have to get a permit. And yes, the Bureau of Development Services will charge you for that. If you go across a right-of-way that is administered by PBOT, there may be some cost associated with the work in a PBOT right-of-way. So this is not the total cost. This is merely the front door. This is legal access to the right-of-ways that are owned by the people of this city.
Correct.
And for that, you are charging a grand total of $650,000 for the small cell service access. Is that right?
Correct.
Okay, good. So if I got this wrong, somebody needs to tell me, because that's what I'm reading, that's what I'm seeing in the proposed ordinance, and it would be helpful for me to understand if there's more to this. Commissioner Gonzalez.
I just had a follow-up question in this area. So one of the arguments we've been hearing from industry is that the city's current fees are out of market. That's the argument, that they're high, and that's leading to underinvestment in the Portland market. that has some digital equity implications if it's true. And so, and by that, let me be crystal clear, right? Closed schools 2020, we send Portland children home. They're dependent on what internet they have in their homes to have access to education. It's not a little thing. It went on for a year. Digital equity has been in vogue as a policy priority in the city of Portland for a number of years. It waxes and wanes. I happen to believe it's quite important, but it waxes and wanes in importance at City Hall. Do you have data on relative investment in the Portland market versus some of these other markets? And certainly we're going to hear from industry, I suspect, on this point, but I'm just trying to calibrate here, because the argument is that we're charging high, that's disincentivizing industry to invest in this market, and I'm just curious if you have ways to calibrate that.
We don't have any direct data. I mean, that's proprietary to each company, and so we don't have direct data. I will note that when you look at your cell phone bills, they are charging jurisdictional taxes. So they are recovering those costs. So the argument that they are not installing and making capital investments, I've not been able to understand when they are able to recover the specific taxes and fees associated with each jurisdiction.
So I think this is actually a really important point, because that raises a separate question, right? We're at a time where we're really scrutinizing what's being passed through to consumers. If we are out of market for what we're charging, wireless carriers, and we're passing that on to Portland residents, it's an area that I at least want us to be sensitive to. So I think this is, Andrew, I take at face value what you just said. I just want to make clear, is this something that's largely being absorbed by the carriers, we think, or is it largely being passed on to consumers? Because there are concerns either way. There are pluses and minuses either way. I feel like on this topic, I've been somewhat unclear. I had assumed it was being passed on to consumers, but if it's just for the initial access, right? Is that what we're talking about, or is it go ahead.
So my background is in utility rate making. I'm an economist, and I've worked at PG and Northwest Natural doing regulatory price setting and rate making. Under that construct, that is transparent rate making and pricing at the PUC. The wireless carriers are not subject to regulatory price setting, and so I can't answer that question directly as to what is included in our taxes and fees within the line items of our bill and what is not. I have been curious about, if we were to look at a customer in Gresham versus a customer in Portland, would we see a disparity, or is the taxes and fees equal? I suspect they're equal, but I have no data to support that. I think, again, it goes back to a transparency in an industry, as an industry, for price setting.
And just to follow the logic, just to your last point there. So Gresham has adopted, one of these codes. If residents there are being essentially charged the same for taxes and fee as Portland residents, which it sounds like that's your assumption. We haven't tested the assumption, but we assume. In that scenario, then the carrier would be absorbing the difference in cost if there's a difference in cost between the city of Portland and Gresham. Assuming the city of Portland.
If Gresham was at a lower tax collection rate.
Let me be clear on my question. So if we're both assuming that Gresham and Portland residents are being charged the same for taxes and fees, right, on their bill, which I think was your assumption. I think that's a fair assumption in the market. If the city of Portland is charging a higher rate to the cellular provider than the city of Gresham is, then the cellular provider in that case would be absorbing the cost difference.
Well, I would argue differently, Commissioner, and say that customers from Gresham are subsidizing customers in Portland for payment of that fee that is assessed for small wireless.
And this is where the assumptions become important, right? Sure. Because I think we're going to hear it, just to preview it, that we're going to hear that that's leading, in such a scenario, that's leading to more investment in Gresham than in Portland if the cellular provider is absorbing those costs and not passing them on through to consumers. So that I understand your point, but that's the argument that
I guess I just want to clarify. if I was doing that cost study, I would look at the jurisdictional costs across the metro area, i.e. the 3 counties, add up my total annual payments to those jurisdictions and spread it across the number of customers within that jurisdiction and divide it by monthly, right? And so that would then average out across whether or not jurisdictional costs for fees for small cells were $1,000 or $1,800 in one jurisdiction. That wouldn't necessarily dictate my investment strategy. It just speaks to because I'm recovering the costs regardless, right?
I think you had me most of the way until the end, but I think for now I'm very, you know, when you're putting together a pro forma on investment and where you're going to, you know, what markets you're going to invest in, we certainly talk about this in housing, right? What are your upfront costs? What are you going to be paying into a jurisdiction? It's not always the most decisive factor, but it is a relevant factor in choosing where to allocate dollars. And so, I think we're reaching the end of what we actually know, and we're making a lot of assumptions. So I just wanted to let's circle back to this as we go through the testimony.
Commissioner, I wonder, to kind of flip the question, is if we were to lower...
Question, or would we see more investment in 5G in the city of Portland? And it's like, that's the,
my mind going here, and I want to make sure I understand, again, what this ordinance is and what this ordinance is not. My understanding, and somebody could vary higher than other jurisdictions for any number of reasons. The permitting fees are too high, the PBOT fees are too high. And so when it comes back, is this $650,000? So the difference really, Gresham charges, take the delta, the difference, and spread it over 650,000 people. That's what we're talking about here. The multi-billion-dollar capital investments, this is de minimis. It's decimal dust. It doesn't matter. Unless somebody can tell me, and I'm not seeing it. What I'm hearing in the testimony I have received, people made really good.
That's correct.
So unless somebody can convince me otherwise, anybody else?
Next up, we have Alex Loop.
Welcome. Thank you for being here.
Thank you.
By the way, I should remind everybody council rules if you're...
So much to get through. I probably can't hit it all in 3 minutes. I'm going to try to hit as much as possible, but I welcome
Before
any...
we start the timer, we will... that he wants to provide that helps shed light on this. I personally would very much welcome it. So you don't...
So let me start here. So over the past 5 years, this broadband service to consumers, households, communities, and small businesses throughout Portland. A code that was negotiated in a transparent, collaborative manner with stakeholders meet those standards. This proposed code and rate structure dollars to cities that have reasonable policies and rates. I want to address the argument that the proposed code does largely been in place since 2018. They are not cost-based, not compliant with. It would create an untenable precedent for a wireless company to embrace Portland's rate, which is more than twice as high as the next highest rate on a West Coast city. Not that you hopefully have with you. Portland really has not done its homework here. This fee analysis appears to us to be a reverse end before the lawsuit against the FCC to maintain those rates. City staff has also argued the rate will go down as more small cells are deployed. Costs for the city, like for tasks like inspections. This is why these have different costs. An apples to apples rate isn't the ask. We are insisting, and I do want to I know I'm over time here. I want to end just by thanking Commissioner Rubio for the amendment. There's more time to work on this. For further work to address the other outstanding issues in the code and rates, and I look forward to...
Do I take it you do support the amendments? You get the point. Good.
Yes.
Thank you. Appreciate it. Thank you, sir.
Next up, we have John Isaac.
Hello there. Good to see everyone again. Mayor Wheeler and Commissioners, my name is John Isaacs. I'm the Vice President of Public Affairs for the Portland Business Alliance, resident of Southeast Portland. I prefer he, him pronouns. You had unanimously adopted about a month ago. On page 11, bring a resolution to City Council to require inclusion of a financial impact analysis when new regulations, policies, or taxes will have an impact on private parties to understand the full cost of companies bearing the cost. We will continue to push the city to remain accountable to this plan. It should and must be the guiding document if our city is going to thrive in the future. We strongly commend the council for doing exactly that with a strong stance against exorbitant new taxes and fees in the adopted 2023-2024 city budget. We ask today that you remain consistent with the fees for accessing the right-of-way. The numerous documents from city staff regarding this ordinance have argued that the city can charge the highest row fees of any major market on the West Coast. Fees that are the most expensive by a factor of 3 or 4 and are conspicuously identical to those charged before losing a case in federal court entitled FCC versus the City of Portland. They have never explained why we are so much more costly than everyone else, and I have not heard anyone within the city consider if this is in the interest of our residents who depend on these services to be available and affordable. In the year and a half we've been involved with this process, we have asked repeatedly for the city to transparently justify these out-of-market costs and to eliminate novel policies included in previous drafts of the ordinance. These sky-high costs ultimately result in higher energy bills, cell phone bills, internet bills, and other essential services provided through the right-of-way. And not only do these fees drive higher consumer costs, they are driving away investment in 5G, which is essential to Portland being competitive in the future. In speaking with one wireless provider representative about this recently, they said to me, maybe the council should ask why Redmond, Oregon has 5 times the number of small cell poles as Portland. We have sent you examples of cost studies conducted by other major West Coast cities. Our request is for the same transparent and thorough evaluation to be completed here. Only then will we be able to understand why Portland is so much more expensive than our competitors, so a pathway can be developed out of this position. I hope we can agree that being the most expensive city by a factor of 3 or 4 to deliver mobile or internet service is not something we should aspire to be. We appreciated the clarification memo sent to you last night by Bureau Director Donnie Oliveira, whose involvement has resulted in the elimination of many of the policy disagreements that existed last year. We greatly appreciate that his memo identified a few more sticking points that have been resolved here at the last minute. We agree with the memo that this ordinance does not directly set the fees, but we take issue with the bifurcation of fees between BPS, PBOT, and other bureaus as somewhat fuzzy accounting. To any company doing business with the city, this is one set of costs. And what better time to evaluate all of the costs, adjust them to be competitive, and bring them into one program than now when charter implementation is underway. And we don't actually know if the comparisons we sent are apples to apples with other cities because the city of Portland hasn't shown us its actual apples with a transparent and thorough cost study. Our ask of you is to give clear direction to city staff that the city complete a thorough cost study that identifies why Portland is such an outlier and presents a plan to bring us into line with other major West Coast markets. Whether through an amendment into the code or through a resolution, this addition will allay our strong concerns today. Thank you for your time.
Thank you. And John, if I could just make a point. First of all, thank you for the time and energy you and the PBA put into this. And I did receive a very thorough letter from the PBA, and that helped me in terms of doing my due diligence and asking the questions I needed to ask. So I want to thank you for the time and energy put into that. I also just want to say none of the things that you're calling for are precluded through the passage of this ordinance. If we still want to talk about the other city charges that go into the development of any further access to the right-of-way, that's still very much on the table. We can talk about PBOT, we can talk about permitting, we can talk about the Bureau of Planning and Sustainability. In fact, those conversations are ongoing both through our budget process as well as other independent efforts that are separate from this ordinance. So that's my point. We can agree to disagree on whether this is the right time or not.
Can I respond to that, Mayor?
Of course.
Okay. So as I just said, we agree the ordinance doesn't necessarily set the fees. So we agree on that. As we stated in the letter, we think it's too much of an ask for any industry to sign off on a policy that's going to set how they interact with the right-of-way without having a thorough understanding of the cost. And as you're hearing already, and I think you're going to continue to hear, there's a gulf. I mean, it's not close of an understanding between the dialogue we just heard between you and city staff, who we've worked with all the time, and where industry is in terms of what the fees are. The analysis we provided, which comes from industry, reviewed by multiple attorneys, including the letter we sent, that went through multiple rounds of legal vetting by industry attorneys, are that Portland is 3 to 4 times higher than any other West Coast market. And as we've consistently communicated to all of you, our concern is our competitiveness and the dramatically rising cost of living here. So that's our main concern. That's how we've engaged in this, is that A, the policy is not novel, that it's consistent with other markets, and that we don't have fees that are that far out of market and are driving away investment and, as we've heard, potentially driving up the costs of essential services.
All right, fair enough. I appreciate it. And I just want to reiterate again, as your letter acknowledged, and what makes this somewhat different than the last time you were at the dais is my opposition was to new taxes, fees, and utility rate increases. This, as your letter acknowledged, it's the same and has been for 4 years. So this is not an increase. So there's no additional burden being asked of our ratepayers.
Correct, but per the FCC order, that is a concern we have, that they are conspicuously the same as they were pre-FCC versus City of Portland. And again, to us, the way you answer the question is through a thorough and transparent cost study. I've heard statements from Commissioner Rubio today, which we really appreciate, Commissioner, and from Director Oliveira, that we'll work on that in partnership after this.
Yeah,
that's what's most important to us.
Just based on the fact that we don't seem to be agreeing on baseline facts.
Right.
I was provided one chart, for example, that I looked at that purported to be the cost of the City of Portland versus other cities, and I am no expert on franchise fee, but it was very easy for me to pick holes in it. So we really don't have a thorough baseline comparison. And that was provided as testimony to me as somebody who was in opposition to this particular ordinance. And that's part of why I went on my my earlier diatribe on this subject. But I'll let you go. Thank you. Thank you for the interaction. I really appreciate it, John.
Next up, we have Trey Hendricks.
Welcome. Thanks for being here.
Commissioners, Mayor Wheeler, thank you for the opportunity to speak today. I'd start by expressing my gratitude for the work and the opportunity to speak with your staffs. They've been incredibly responsive, generous with their time, open, knowledgeable, and inquisitive about our issues. And I would like to thank them for that, and thank you. When I heard that I would have 3 minutes instead of the 9 that I had planned in my comments, I had to make a decision about whether I would read my comments at triple speed or cut them back or just throw them out entirely. So what I'll try and do is maybe answer a few of the questions that you've asked. The reference to the $650,000 cost associated with administering this program strikes me that there's some kind of a disjunct between what the staff has been trying to do and what the actual impact is going to be on the companies. And for Ziply Fiber, who I'm here representing today, it would be significant depending on how the fees are calculated. Ziply Fiber has 58 miles of fiber in the city right-of-way. At the $5 a mile or foot rather, we estimate it would be about $1.5 million a year in fees, which is significantly higher than the $650,000 cost associated with administering the program. And maybe that's a conversation that we still need to have with staff to sort of understand that. It's also possible that because Ziply is a utility provider in the right-of-way in the city, that it would be a gross revenue, I guess it's called a derived gross revenue calculation for the use of the fiber, which transits a significant amount of internet traffic. That number, we haven't done a calculation on that, but I would suspect it would be significantly higher than $1.5 million a year. And given that cost, I've been told by the company that in no uncertain terms that if that were going to be the cost to stay in the right-of-way, Ziply would move its fiber elsewhere and probably abandon the Pittipicket building as a hub for its internet traffic. It would just simply be too high of a cost for a company with a 4-state footprint. And then the final point that I'll address is digital equity that Commissioner Gonzalez raised. And we also think that's critically important. As you may be aware, the Broadband Office in Oregon is conducting a rulemaking to determine how hundreds of millions of federal dollars are going to be spent to help get enhanced broadband access to underserved Oregonians, and in Portland as well. This will add to the costs associated with building those projects, and because there will be matching requirements to get that money, it could have a pretty chilling effect on companies' ability to do those builds. And that's really a statewide effect as well as Portland and surrounding communities. So what we're essentially asking for is that we have some additional really thorough vetting process in written comments and stakeholder workshops where everybody can get together and have that conversation and try and clarify some of these issues. And I can take questions, and thank you again.
Great, thank you. Appreciate your testimony. Thank you.
Next up, we have Alan Galloway.
Welcome. Thanks for being here.
Good afternoon, Mayor Wheeler and honorable commissioners. Thanks for having me. My name is Alan Galloway. I'm an attorney at Davis Wright Tremaine. I am pleased to be here today representing T-Mobile. T-Mobile supports many of the city's expressed goals with respect to the ordinance, but opposes the ordinance as written. And I want to explain why, as we did in our comments. First, I just want to note that we've tried to engage with the city from the outset. T-Mobile has now submitted 3 rounds of formal comments and worked with the wireless industry to try to discuss concerns and raise concerns about federal law with staff throughout the process. I really want to appreciate Commissioner Rubio, the amendments that you announced today. Those are a further step in the right direction. I also want to appreciate that staff has done a lot of work on this, and I know that this is not easy. I know the federal law on this is not necessarily the easiest to understand. While the process has gone a long time, I don't feel that we've made a lot of progress until recently. Recently, things have started to change. The last draft was a small step, but a significant step forward towards compliance with federal law, and I want to appreciate the fact that the new draft appears to take steps to clarify that fees on small wireless facilities and other wireless facilities are going to be facility-based, that they're not going to be subjected to the gross revenue fee that was stated elsewhere in the ordinance. And T-Mobile appreciates that step. That step is necessary, in fact, to comply with federal law. Under federal law, it is unequivocal that fees must be cost-based. That is required by Section 253 of the Communications Act, and with respect to wireless facilities, it's also required by Section 332, as we've explained in our comments, and I invite you to read those. The fees in the fee schedule currently, it's not clear that they meet the requirement that they be specifically related to and caused by the deployment of wireless facilities, and that they are not only a reasonable approximation of the city's costs, but that the costs themselves are objectively reasonable. Although the city has very recently provided a small cell fee analysis just this past week, that document doesn't have enough detail to tie those costs to deployment in the right-of-way. Doesn't have detail supporting the city's allocation of costs of salaries and personnel, and it doesn't have any showing that those costs are objectively reasonable. So more work needs to be done in this area. The city should also revisit the lease consent requirement, which is an obstacle to deployment, as we've stated in our comments, and should revise the burdensome and unreasonable indemnification provision in the current code that indemnifies even where there's no fault or no unlawful conduct by the provider. Requires the city to be indemnified for its own negligence. That's not fair. We recognize that this has been a long process. Again, I would like to also be able to say we made a lot of progress. I think, though, that we are beginning to make progress. I think that there is a possibility that with the current staff and the willingness that has been shown today to address some of our longstanding concerns, the definition of small wireless, thank you, we could get this right. But it is going to require a little bit more time. T-Mobile would be happy to work with the city to do that and to make this code the code that the city deserves, to encourage the wireless service that the city deserves. Thank you.
Thank you.
Happy to take any questions if you have some. If not,
thank you.
All right, thanks.
Next up, we have Jeremy Crandall and Christine Crow online.
Welcome.
Great. Can you hear me okay?
Yep, loud and clear. We see you as well.
Excellent. And I don't see the timer, but I'll You can bear with me. I'll just do one myself right here so I don't go over. Mayor Wheeler, commissioners, my name is Jeremy Crandall. I'm here to there we go. Thank you. I'm here to testify on behalf of CTIA, the Wireless Industry Trade Association, with some comments and concerns related to this ordinance. My colleague, our legal counsel, Christine Crow, will speak after me. Together, we'll briefly summarize our perspective on several key elements, and our perspective is also more extensively outlined in our submitted letter that's in your portal. I will also just thank you all for the ability to speak on this ordinance virtually from Washington, D.C. Let me begin by saying that CTIA and our members are strongly committed to doing what we can to improve connectivity for residents and businesses across the city. As we all learned during the pandemic, innovations in telehealth and distance learning required enhanced, reliable mobile connectivity. Cities, residents, schools, and businesses and institutions continue to demand exceptional wireless service. And so our members are committed to ensuring that no community is left behind. I heard the conversation about digital equity. We're doing that by investing tens of billions of dollars right now in infrastructure nationwide, $35 billion in 2021 alone in private funding to upgrade our infrastructure. And that investment fuels economic growth in Oregon, where our industry supports more than 50,000 jobs, generates $17 billion in annual GDP growth. Our members are doing everything they can to work with state and local officials to build those networks. And responding to this exploding growth does require policies that ensure regulatory predictability for our members. I do want to speak on one example specifically where we believe the ordinance creates some needless and unnecessary barriers and challenges for deployment. Again, it's outlined in our letter, but one example is the code is drafted presently would regulate service providers that do not install any equipment in the right-of-way, but merely use others' equipment. For background, a wireless provider may often send its traffic over another provider's physical network or resell the services of a provider with facilities in the right-of-way. And so when this occurs, it imposes no essential burden or cost on the city in terms of right-of-way management, because it does not require installing antennas, fiber, or other types of equipment. And as such, it would seem to make little sense for Portland to subject those providers to licensing, fees, insurance, audits, and other requirements of the proposed code. A more sound approach that does not include this provision would in fact encourage our providers to use the facilities of others, and that would minimize the number of separate facilities occupying the right-of-way, which is something that I know many folks believe is very important. So in closing, given the exploded demand we are seeing from consumers for more services, we'd very much encourage. I'll stop there. Thank you.
Thank you. Appreciate your testimony.
Next up, we have Christine Crow.
Hi, Christine.
Wilkinson Barker Nauer LLP. I'm located in Washington, D.C. And again, I am testifying on behalf of our client, CTIA. Mr. Crandall raised a letter that CTIA filed in anticipation of today's hearing. First, the fees for wireless facilities the Bureau asks you to enact do not comply with federal law, rights-of-way management in connection with these facilities. We therefore ask that you not adopt the proposed fees and instead require that fees far exceed the amounts that the FCC determined in 2018 were reasonable, amounts that a federal appeals court upheld. Although the Bureau just days ago attempted to just inconsistent and unexplained assumptions about costs, and it supplies no basis for fees for larger wireless facilities either. In addition, as CTIA's letter explains, the service in the fee schedule, which the Bureau has declined to date to confirm explicitly will not be facilities within the rights-of-way, also violates federal law. Revenue-based fees have long been rejected by courts because they are, by definition, law to determine whether to lease spectrum capacity on its facilities or to make physical space on its facility available to other providers. Portland should encourage these practices because third, the indemnification obligation is overly broad and would require providers to indemnify Portland based on the mere presence of facilities in the right-of-way. The provision goes far beyond what intended. Given these issues and others that have been raised with you today, we ask that you defer adopting the code at this time and ask that the Bureau consider these concerns.
DC time. Thanks.
Next up, we have Daniel Schweitzer.
Hi, Daniel.
The nation's largest shared communications infrastructure provider. Currently in the city of Portland, we have 23 small cells and 75 towers. I want to thank you for this opportunity to utility operators. We appreciate that the city's stated intent is to streamline the franchise process for all users of the public right-of-way. However, which as you know has been upheld by the Ninth Circuit. Specifically, communications infrastructure providers who build small cells in the right-of-way that are connected by fiber that also is located in the right-of-way, we are concerned that the fees proposed by this legislation are not customers who utilize our facility to provide the wireless service that we all expect and rely upon. Is the city intending to charge Crown the fiber included in the small cell attachment fee as we believe it should be? It is not clear in this legislation. Furthermore, is the city intending to charge our customers for usage of our infrastructure? As a reminder, each on a percentage of gross revenue or linear foot fees are not cost-based, and we stood clarification from staff and from each of your offices, and to date, no one has been able to answer these critical questions. In fact, I believe that it would be prudent to understand the cost before this legislation moves forward. So I've spent a little bit of time talking about some of the technical aspects of the ordinance, but we have a robust economy and can be a driver for growth. 2, health and safety considerations cannot be ignored in regards to connectivity. Today, over 80% of 911 calls and emergency services are made in other cities. For these reasons, I believe we should press pause on this ordinance and convene industry stakeholders and city staff to create a lawful and efficient set of guidelines concerning the deployment of communications networks within the city. I have a serious concern about $4.95 linear fiber fee for existing fiber. I don't understand. We are on the precipice of a large small cell deployment in the city of Portland. This ordinance will incurring annual ongoing costs with having existing fiber underground. That's $1 million of unbudgeted OpEx that the city is collecting, and the reasons are unclear because we haven't seen.
Interesting one to me too.
If I'm misreading it, I hope I am. If the fiber that's feeding the small cells is exempted from the fee, as it should be, because it's pertinent to a small cell facility, it's a different conversation. Others may have concern, but as drafted, it's unclear at best.
Okay, thank you for
Thank
that.
you very much.
Yeah, appreciate your welcome.
Yes, well, good afternoon, Mayor Wheeler and Commissioners. My name is Sophia Steele, and I represent members of this City Council, and residents of Portland have shared their desire to prioritize clean and safe energy. WISPA and our members share this desire. Unfortunately, we're here today in opposition to these updates, and we have specific concerns with the provisions addressing the fuel pipelines. As you know, pipelines provide the safest, clear with the operation and maintenance of existing fuel pipelines, as well as discourage the construction of new pipeline infrastructure. During the shared goal of clean and safe energy, we respectfully request the changes to the fuel pipelines be removed. Thank you for the opportunity to testify on concerns outlined in detail.
Awesome, thank you. I appreciate that. Thank you for doing that.
Mayor Wheeler, members of City Council, my name is Skip Newberry. We're testifying today in opposition to the proposed rules, labor those points. Now, I think productive conversations have been under, I think, by some of the amendments that were offered up. I think good work is undergoing, and we apply around exactly how the underlying facts were arrived at. There are some questions, right, in terms of some of the underlying assumptions as it relates to how the fees were calculated. And we increasingly digital world, and it's important that we take the time now, I think, to make sure the policy is as good as it can be. Today, as it relates to a logical next step being a transparent cost study, competing with for businesses and, frankly, residents as well. So thank you for your
Simca.
Welcome.
Thank you. However, the good part was that Crown Castle was here, because I don't think people really understand what getting away, but we are engaged in a customer war with Comcast. They want to see Comcast subscriptions fall. 2 years from now, we'll sit back and go, oh my God, broadband in Portland costs 1.7% more than it costs in Seattle. I don't know if that's a very determining factor. Maybe it'll turn out to be less. But 40 city attorneys that have looked at the Ninth Circuit's opinion about what the FCC says. You have to scooch a few $100,000 out the door to private counsel because the city attorney's office doesn't feel ready to go to the ninth. We'll continue to put towers in. They'll put a tower in, and then some Verizon equipment will get hung on there, or maybe just they'll put equipment on there and they'll lease that equipment to Verizon, and Verizon won't even own it. And then possibly localities can only look at the right-of-way impact. You can word it either way. You can revert it as a great service provision opportunity, or, of course, if you feel like the city attorney's office has had a reasonably talked with you about the Ninth Circuit's opinion on how the federal rules, there's a chance you'll get sued. As you spent many minutes talking before, we have this question of why all the hoopla when these are not the actual fee schedules, although we've heard about cost per mile or what on fiber.
Questions, we will get to the amendments today, and then we're going to pass it on to second reading, but did anybody have any follow-up questions for staff? Great conversations over the course of the next week, so thank you for taking the time to be here. With that, then, we'll get to Commissioner Rubio's first amendment. This was the directive that this ordinance meets the requirements of a prior resolution regarding work sessions and executive sessions. Any further discussion on amendment number 1? Please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The amendment passes. The second amendment revises the definition of a small wireless facility as defined by the Federal Communications Commission. Any further discussion on this amendment? Seeing none, please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
I just want to thank Commissioner Rubio and her team as well as the city team for working with industry. I should have said this on the first one. On all three of these, I appreciate that. I vote aye on the amendments adopted. And last but not least, Amendment 3, it adds a new subsection to the utility-specific provisions code in Exhibit A. Any further discussion? Please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The amendment is adopted. This is a first reading of a non-emergency ordinance. It moves to second reading as amended. Thank you, everybody. Next item, 472, please.
Amend the Planning and Zoning Code to adopt vehicle parking reforms to comply with state rules.
Colleagues, today we're holding a hearing on parking compliance amendments project. This project is being brought to us by the Bureau of Planning and Sustainability, so I'll pass this over to Commissioner Rubio. Commissioner Rubio.
Thank you, Mayor. I'm pleased to introduce this ordinance that proposes zoning code amendments to bring the city into compliance with the new state of Oregon parking rules. The rules are intended to support the state's goals for reducing transportation-related pollution, which accounts for approximately 38% of Oregon's climate pollution. They were adopted by the state, and all cities must comply by the end of this month. The project removes minimum parking requirements citywide and adjusts parking maximums and parking lot standards to bring the city into compliance with the state's new rules. And I'd like to thank the staff for their great work on this. I would also like to thank the Planning Commission for forwarding the recommendation for our consideration. This is the first recommendation we've received from the new Planning Commission since its formation early this year. Before I pass this on to staff to begin the presentation, I'd like to introduce a package of 3 minor technical amendments. Staff brought the need for the amendments to my attention and have submitted a memo into the record dated June 2nd, 2023. These amendments were included in the clerk's Tuesday memo for council and the public to review in advance of this meeting. The amendments bring the city into compliance with even newer updated rules adopted by the state earlier this spring that are more feasible to meet. I've asked the staff to explain the technicalities. So Sandra, can you please share the details and show us the slide with the proposed amendments?
Yes, thank you. Good afternoon, Commissioners and Mayor. My name is Sandra Wood with the Bureau of Planning and Sustainability. I'm the Code Development Manager, and the 3 amendments that Commissioner Rubio was describing are on the slide before you. The amendments basically change the rules to development standards that apply to parking lots, that advance what we would consider green features of those parking lots, and they would only apply to large parking lots. In essence, these changes reduce the regulatory requirements for parking, for which parking lots need to meet the green feature standards, and reduces the requirement for tree canopy coverage from 50% to 40%. The actual changes to the code language are shown in the Parking Compliance Amendment Project as amended draft that has been linked in the item on the council agenda. Next slide, please. And as a part of housekeeping, part of the amendment is to replace what we originally filed as a council filing, which is the Planning Commission's recommendations, with new documents that show this amendment reflected in the new documents. We wanted to thank Commissioner Rubio for bringing this, for moving this amendment forward, especially before the testimony. We appreciate you making this change, and it brings us back into an alignment with the state rules. With that, I'll pass it on to J.P. McNeil. He is going to present the Planning Commission's recommendation.
Should we vote on the amendment first?
I think you need testimony first.
Oh, yeah.
Okay, so just to be clear, these appear to be technical amendments. Would you describe them as such?
Yes.
Okay, very good. Why don't we put them on the table for
Okay.
discussion? Do you want to move?
Yes, I move that the council move the amendments as described and replace the documents shown on the slide.
Can we do them as a slate, or do we need to do them individually?
Do you need a second?
As a slate was what the city attorney said we could do.
Very good.
Second.
Commissioner Ryan seconds. The amendments are on the table. Thank you.
Great, thank you. And then the public, hopefully, can testify on them. And we've posted them on our website last week.
Yeah, great.
Okay, good afternoon, Commissioners, Mayor. I'm J.P. McNeil. I'm a planner with the Bureau of Planning and Sustainability, and I'm going to talk to you about the Parking Compliance Amendments Project. This is a response to mandates for parking reform in the state's climate-friendly and equitable communities rules, or just climate-friendly rules for short. Next slide, please. So there are as a quick overview, there are 3 main proposals with this project, and they are to remove minimum parking requirements citywide, to update and simplify the maximum parking requirements, and to add some new development standards for large parking lots. So, next slide, please. So the first proposal is to remove the minimum parking requirements across the city. As of now, there are only a few remaining areas in the city that still have minimum parking requirements, and so this project proposes to remove them to comply with the climate-friendly rules. That's the bulk of this project. And I'd also like to point out that removing minimum parking requirements does not equate to no parking with future development. Developers can still build parking. It just means that the amount provided isn't set by the code, but it's determined by the market. So next slide, please. This map illustrates the areas where minimum parking requirements are proposed to be removed in purple. So the areas where we're talking about, where we're removing minimum parking requirements, are generally on the outskirts of the city. It's largely industrial land, parks, and open space. And because of that, the impacts are minimal because minimum parking requirements have already been removed in most areas of the city. And as I said before, parking, it's not prohibited. It can still be provided to accommodate uses as needed in these purple areas. The next proposal is...
Next slide, please.
Oh, sorry. The next proposal is for the maximum parking requirements. In the rules, the state requires cities to adopt maximum parking requirements. Portland largely complies with those rules already. We have maximum parking requirements in place because of metro rules, and so we're just updating our maximums to align with the state rules and simplify some of the parking ratios. Next slide, please. The last proposal comes in 2 parts, the large parking lot development standards. The first part limits the size of surface parking lots for buildings that are larger than 65,000 square feet in size. So think of a big box retail store. And so in that case, the surface parking lot can be no larger than the building itself. So a 100,000 square foot building can only have a surface parking lot of 100,000 square feet. Next slide, please. And the final piece of this is the large parking lot green features. As Sandra mentioned, so currently, as proposed by the Planning Commission, it applies to parking lots over a quarter acre in size. One of the amendments is to up that to half acre in size to trigger these requirements. The requirements that are triggered are to either incorporate tree shading for new, larger parking lots, solar power generation on site, or for public buildings that can meet green energy building requirements that currently exist, but that only applies to public buildings. And then the second piece to this is that access ways, the major travel routes through a parking lot, need to include trees along the edges and pedestrian pathways along the edges of those access ways. The reason we're here today, I've mentioned previously about the climate.
Next slide,
Oh,
please.
sorry. Just do that. The reason, as I mentioned, the climate-friendly equitable community rules, the state adopted those last summer, and they require communities to update their land use and transportation plans to support the state policies to reduce Oregon's greenhouse gas emissions by 75% by 2050. So the project is in alignment with that. It's also in alignment with city policy as well, including several comprehensive plan policies related to reducing parking demand and managing the supply of parking to limit the development of off-street parking for land use and transportation and environmental goals. Next slide, please. Our community engagement for this project has been, it's a compliance project, and we have a short timeline. It needs to be adopted by, in effect, by June 30th. So we were pretty limited on our time frame, but the states had a 2-year engagement process for the climate-friendly rules, since this is a state mandate. So much of the engagement took place at the state level. Locally, we reached out to the district coalitions and some neighborhood groups. We met with the ones that asked for a meeting. We asked the district coalitions to send notice of the project to the neighborhood associations in their districts. We also presented the proposal to several of the public commissions, the Design Commission, Historic Landmarks, and we also had a public hearing at the Planning Commission on April 11th, 2022. And here we are. 20, oh, yeah, you're right. And then the public hearing today at City Council. And with that, I'm going to turn it over to Sandra for some housekeeping.
Yeah, so at this point, we did have some pieces of written testimony. I think there's 8 pieces of written testimony in the map app for this project before you. And there's additional evidence in the project record on the auditor's website. Next, please. So what we're asking the City Council to do is to consider the Planning Commission's recommendation, and the procedure would be to vote on the amendment that Commissioner Rubio put on the table, and then to vote to approve the emergency ordinance, which adopts the as amended draft and amends the zoning code. As JP mentioned, we do have a June 30th deadline per the state, and that's why we're proceeding with the emergency ordinance. Thank you.
Thank you. Colleagues, any questions? Public testimony?
We have one person signed up.
Very good.
Katie Gould.
Hi, Katie. Thanks for being here.
My name is Katie Gould. I'm a senior transportation researcher with Sightline Institute, and I urge you to vote yes on this proposal. And I know there's not a lot of controversy around this, right? I'm the only person testifying about parking. That's new. But I wanted to take a moment to acknowledge the historic moment that we're in right now. Over 60 years ago, back in 1959, Portland began requiring predetermined amounts of parking for every new home, business, civic institution as a condition of development. These rules have blunted home construction, they've killed small businesses, and they've forced new buildings to be literally designed around cars. We've long been aware that these rules are problematic, which is why we've made so many exceptions to them over the years. There are so many carve-outs for parking mandates today in Portland that even the most ardent parking reformers would say we're essentially eliminated. But these rules are still on our zoning code, and other cities are still copying us and those codes that are in there today. because Portland has long been considered a really good leader in good urban planning policy. Which brings me to today. Because of this state action, we can finally leave these regulations in the past where they belong. That being said, when parking controversy has happened, I'm thinking specifically a decade ago when I first moved to Portland around Division Street, this city council has looked to parking mandates as a solution to resolve people's concerns about street parking. And while that's maybe good politics, it's actually done very little to solve people's actual parking issues. So moving forward, now that we don't have this tool, we need to be more comfortable using the other tools in our toolbox that actually work, like meters and permits. And I would urge the city to take a more proactive role in managing its parking supply in the future and implement the pricing policies that have already been recommended by the POEM Task Force. Thank you.
Thank you. Appreciate your testimony. Thanks for being here.
That completes testimony.
Very good. This is an emergency ordinance. If there's no further questions, please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
I want to thank, again, BPS staff for all their great work on this. And I'm also grateful that our city
I'm
is...
sorry.
Amendments.
I forgot to vote on the amendments. Can we hold on the vote? Let's go to the amendments. Please call the roll on the amendments.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
All right, so the amendments are on the table. Commissioner Ryan, do you want to keep your vote where it was?
Yeah, but do I have to do it again?
Why don't we just do let's
do it again
Sure.
otherwise.
make it clean? Exactly.
Yep. Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Thanks again to the BPS staff who worked on this and for all your great work. I'm really grateful that we live in a city that has already done a lot of the heavy lifting and on a lot of parking reforms. So the changes in front of us, while they're significant, it also feels in many ways like minor code cleanup because of our progress so far. So this is just one of the many things we're doing to move Portland forward, and every part counts. I vote aye.
Wheeler.
Aye. The ordinance is adopted as amended. Thank you all. Back to the regular agenda, second reading, item 473, please.
Amend City Code to update existing public camping restriction policies to comply with House Bill 3115.
Colleagues, this is a second reading of the time, place, and manner ordinance council heard last week. We had substantial public testimony on this item. I want to thank everybody in the public for your engagement. We had almost 200 people sign up to testify in person. We have received almost 700 written comments. Council did not have the time to hold a discussion on this item last week, so I'd like to welcome my colleagues to ask any questions or share any comments they may have. Staff is here to answer any questions. Why don't we have staff come up just so we're here and ready to go in the event that anybody has follow-up questions? Colleagues? I may have just made you walk up here for no apparent reason, but at least you got to stretch your legs. Very good, colleagues. Any other, we've had public testimony, we've had the staff presentation. Any further discussion on this item? Seeing none, please call the roll.
Ryan.
Yes, last week we had lengthy testimony on this ordinance, and since then thousands of Portlanders have submitted written testimony and comments. Every day I talk to tenants, property owners, employees, families, and elders who no longer feel safe in our city. Portland, you have been patient. I hear you. Your patience has run out and the status quo is not working. We are building a robust system for those who wish not to be homeless. We are committed to accelerating those services, and we will continue to push Multnomah County to deliver more as they own and fund these services. As leaders elected to serve this city, we must be honest with ourselves. There are many people on our streets who refuse these services. For those refusing, we need to stop enabling and allowing people to do illegal things on the streets. We need accountability. We must continue to differentiate those who are ready to receive services so we can help them quickly by building resilience and expediting the transition into housing and life off the streets. For those suffering from addiction and refusing services, We need to send a message that Portland is no longer a safe haven for criminal behavior, and crime will not be tolerated. This proposal focuses on the homeless community that refuse services. To our day service providers like Rosehaven and Blanchet House who testified last week, I hear you. Local government must provide more support for your operations to ensure those who need somewhere to go, somewhere to be during the day can find respite. As poisonous drugs take over our city and our great state, the city, the county, and the state must align efforts to take urgent action that impacts our ravaging people in ways no one has seen before. The first step to recovery is to admit we have a problem. The mayor's proposal demonstrates an honest, thoughtful, and balanced approach to managing public spaces. Portland's best days are ahead of us. With hope for recovery, I vote aye.
Gonzalez.
I am going to vote aye today. As mentioned last week, I'd hope to strengthen the mayor's proposal. I do have some concerns about the complexity of it, what that means for implementation, but we're not going to let perfect be the enemy of the good. This is a step forward. If the city commits to actually carrying out on enforcement, it will improve things on the streets of Portland. I feel very strongly about this, and I'm just going to reiterate the reasons why. A particular focus is on criminal behavior that has occurred at times in the city of Portland. It is not targeted towards those that are suffering from economic upheaval that we need to continue to support on our streets. The homeless problem is complex. It is multifactorial. There are multiple segments within that population, those that we need to continue to offer a helping hand to, and then others that we need to drive out of the city. And when we talk about driving out of the city, that's criminal behavior. We did receive a lot of positive support for our amendments, but there isn't sufficient political support at this time. So we decided not to pursue. And to my colleagues, I hope we can continue to keep focus on improving safety and livability in the city of Portland, the city we all love. We're going to have some tough conversations. We will have, at times, very vocal minorities that will oppose what is the right thing to do. But this ordinance, this change in code is a step in the right direction, so I vote aye.
Rubio.
I want to thank everyone who's called, testified, emailed, and written about this important issue. As I've shared with the mayor's staff who've graciously spent a lot of time with me and my staff on this issue, I'm voting no today, and here's why. The spirit of this ordinance is to balance the very real need to get more people into a variety of shelter options and the safety and livability of neighbors throughout our city. And that is a hard balance to strike. I hear, know, and understand the concerns that we all face when we are seeing crime, livability issues, trash, and all the concerns that people very validly have. Nothing about this work is easy. And that's why I want to lift up the hard work of staff and of city and county employees, from Street Service Coordination Center to Safety Net and first responders to Project Street Response, and everyone else who are out in our city every day working with our houseless community members and working to make sure our city is ensuring accessibility, safety for all Portlanders. I also know that the mayor's intent here is not to put in place a green light to arrest people. That I don't doubt, but for me, I need to see that this ordinance is planful about its impact and does not cause harm. As I said last week, this council had a public discussion last year about our values related to camping bans. And while we agreed a policy would be need to discuss and put on the table in the future, we also committed to exclude any provisions that would criminalize people solely for being homeless. And it's not clear to me at this time if this ordinance maintains that commitment. And by giving all people involved, whether that is neighborhood associations, shelter providers, police officers, security plans to address gaps accordingly. For example, I would have preferred that our timelines match with the increase in available shelter sites. I would have preferred to give our new training dean, who starts tomorrow, the time they need to train our officers, not only in the details of the ordinance, but also on our expectation that any enforcement mechanisms will be carried out with dignity. There's a shared understanding about where people can go or be referred to. And I think one suggestion that we heard last week was a resource list or map, which I thought was a good idea. But to move the sense, as I see it, the success of us solving the houseless crisis rests in our ability to work together jointly, as we saw play out during testimony last week. And I know that we're all tired and saddened by this narrative. Finally, before I cast my vote, I want to be houseless community members very much need. And I stand with the mayor 100% on this and will do all I can to ensure its success. In addition, my team can different individual needs and to provide a path away from the houseless crisis. We need to do all of the above, and I'm committed to everything we are doing except for this one step. I vote no.
This be read into the record. This is Commissioner Mapps. I support this time, place, manner ordinance. I thank the mayor and his staff for leading on the nations for our streets. Portlanders have been consistent and they've been clear. Unfettered camping and the behaviors that accompany it are unacceptable. Until the pandemic, when we were heeding CDC crisis that is inherently unsafe for everyone. I see this ordinance not only as an end, but as a beginning. Portlanders are compassionate people and want folks to transition off the streets voluntarily, where involuntarily homeless can and cannot camp. We're also working tirelessly on alternative shelters that are resource-rich in drug and mental health residential treatment. Again, I want to thank Mayor Wheeler for this clear-eyed and thoughtful resolution to the problem of this update to our city code is necessary to comply with state law and with Martin v. Boise 9th Circuit decision regarding camping in the city of Portland. I also want to thank Governor Kotek as well as Chair Vega Peterson for their incredible leadership and partnership sites as well as the existing Safe Rest villages. These reasonable restrictions, now codified in city code, updates existing city code and incorporating system before any penalties are applied. We've also worked in partnership with our city bureaus that operate within this space to ensure that as well as outreach, with an emphasis on ensuring the homelessness navigation outreach teams have the clear and thorough information that they need on this new ordinance. My team will also work with our civilian training dean who starts education for our Portland police officers. These reasonable restrictions, coupled with our work on increased, personally thank my staff, Skylar Brocker-Knapp, who is here, as well as Sarah Morrissey, my deputy chief of staff, and indeed the entire staff in the mayor's office for their long-standing and tireless. Next item, also a second reading, 474, please.
Amend contract with Squire Patton Boggs for federal representation for a one-year extension and increase amount by $198,000.
On this item, seeing none, please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The ordinance, time to walk us through this ordinance last week. This one-year extension will better align OGR's timeline on RFPs with the implementation of the city's charter transition to ensure smooth federal relations services come to
Dollars in anticipation of the Fire and Police Disability and Retirement Fund levy for FY 2023-24.
second reading. Any further discussion? Seeing none, please call the roll.
Ryan.
I'd like to thank our firefighters and police officers for continuing to serve our city. We are grateful. We appreciate you. I vote aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
I want to thank the city's debt manager, Matt Gurok, for walking us through the ordinance last week. The issuance of the short-term notes is obviously required to pay fire and police disability and retirement fund benefits early next fiscal year while we await the collection of the property tax revenues that are not received until late November. This is necessary. I vote aye. The ordinance is adopted. Next item is 476, a second reading.
Authorize Portland Parks and Recreation to establish and collect fees in lieu of mitigation activities to implement restoration projects in natural areas.
Any further discussion on this item? Please call the roll.
Ryan.
Sorry. This change in authority makes good operational and financial sense. I'm really grateful. I vote aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The ordinance is adopted. Next item also a second reading. Item number